another lecture video for Political Science 1, Intro to Gov, and we'll be covering Chapter 4 in the American Government book, the free book that's online. Hopefully you all have either been downloading it or have been accessing it. And this chapter is on civil liberties. And again, these notes are just kind of like a very, very superficial compilation of the key things you'll have to know for the midterm exam. And I really like this chapter. I'm trying to make, again, these videos short. But I like this chapter a lot. I think chapters 4 and 5 are arguably really the most important chapters that we'll read with regards to civil liberties, and then our next reading next week will be on civil rights. Just because these are things that we all kind of have a sense of understanding of. People are, very active with regards to these kind of issues right now, and I think honestly some of the people that are online or on social media talking about this stuff don't necessarily entirely understand it. So hopefully we all get a sense of what these things are and just better educate ourselves. So let's just jump into the material. So I have here, this section of the course reading reviews the Bill of Rights of the U.S. Constitution. We generally know the Bill of Rights as the first 10 amendments to the Constitution. These amendments are changes or fixes, right? So we're amending, we're fixing the Constitution, like mending a wound. That's what the amendments really are, right? They're just fixes to problems that arose in the U.S. to the original Constitution that could not solve or alleviate the many of these words. And again, I think civil rights will be a really good example when we get to that next week. Be sure to have a sense of what the first 10 amendments are or do in preparing for the midterm exam. So please read through. So this chapter is basically organized in terms of like talking about all 10 amendments. 9 and 10 are very, very important. You want to have a sense of what they do, but you don't have to have these memorized. You just want to know, like, basically what they do, right? So 10 kind of reserves, Amendment 10 reserves unwritten, unenumerated rights to the states. So just because it's not written down doesn't mean you don't have it. And 9 is very similar, but it applies to people. So people have rights. Just because they're not written down doesn't mean you don't have them. So the key term to know there are the Anti-Federalists from Chapter 3 and Chapter 2. They basically were the ones that kind of fought or were very dubious of like centralized power. But for us, in these notes, in my discussion, I'm really going to focus on Amendment 1, Amendment 5, and really the compilation of rights that kind of form the right to privacy. So we don't have a right to privacy written anywhere. It's not that's probably going to be a test question, maybe not. But yeah, so we don't really have a right to privacy like the way we have a right to own a gun, but we still do indeed have a right to privacy. It just kind of comes from several of the amendments in the Constitution. So again, what then are civil liberties? Again, this is knowing the difference between a civil liberty and a civil rights, really, really important. Right? So the Bill of Rights protects the rights and freedoms of individuals. As the U.S. has developed, now we think of these constitutional requirements as applying to all persons inside or subject to the authority of the United States. So that's changed over time, actually, partially because of the 14th Amendment. And as we do more readings, you're really going to want to, again, have a sense of the 14th Amendment, and in particular, the Equal Protection Clause. But because of that amendment that was passed after the Civil War, the Constitution does not just apply to citizens. It applies to anyone subject to the authority of the United States. That's actually part of the undocumented immigrant, illegal immigrant kind of controversy right now. But someone can ask me a question, or we can talk about that in class. This means that one does not necessarily have to be a U.S. citizen. Okay. So again, what is a civil liberty? Obviously, it's a key term. These are limitations on government power. They protect the freedoms that the government may not legally intrude upon. So they're not exactly like a civil right. They have to do with protections from the government. So another way of thinking about civil liberties is that they are laws erected in the framework of the country to tell the government what it cannot do. For the most part, there's a few exceptions that we'll get to. And so when you're telling someone or the government what their obligation to not do something, this is called a negative duty. So it's not negative in the sense that it's bad. It's negative in the sense that you're telling someone not to do something. Whereas a positive duty, again, hopefully you're taking your own notes if you're watching these lectures. A positive duty kind of ascribes a positive action, something you have to do in the world in order to fulfill that right. I'll give you a perfect example when we get to it in a few minutes. So from page 110, the Constitution itself, without the amendments, does place limits on government action. So again, this is where the Federalists thought that there were already sufficient protections in the Constitution that protected people's civil liberties. But I think Time and the Anti-Federalists kind of showed that this is not the case. So we have a few examples you're going to want to pay attention to. Prohibits the Constitution, that is, prohibits bills of attainder, meaning the conviction and punishment of people without a trial. So in our country, you have the right to a speedy trial, you have the right to face your accusers, and you have the right to have a trial in the first place, right? So you can't just be sit in jail because the government says you're a bad person. They have to essentially prove their case, right? So that empowers the individual. Prohibitions or prohibits ex post facto laws. That just means after the fact, making new things crimes or worse sentences, right? So I say I go to jail for, whatever, stealing, and the maximum sentence is say 5 years. But let's just say that my political enemies don't like me, and they go, "It's 100 years sentence now." It's like, whoa, what? I stole a Snickers bar. So we have prohibitions against that. And less stable, less legitimate governments, they can do what they want. You can just rot in jail. In China, the Uyghurs, they just happen to be Muslim. They're basically going to jail. I mean, they're calling them concentration camps, which is just a form of jail. And they're just saying like, well, until you stop believing in Islam, then you don't, not a good Chinese citizen, which hopefully you'll find to be abhorrent. Limits the suspension of habeas corpus, just meaning having a neutral judge that is going to hear your case when you're being lawfully detained, right? So they're not on the side of the government. They're just kind of like this independent body, which, that's perhaps a dubious claim. Key term here, selective incorporation. The Constitution effectively inserts parts of the Bill of Rights into state law and state constitutions, even though it does not do so explicitly. This is an ongoing process that is still occurring today. So this is where a lot of the civil rights struggle stemmed from. And the 14th Amendment was erected to kind of like make this even a stronger kind of selective incorporation. But there's aspects of the 5th Amendment that do this that just didn't seem to work. So again, America is kind of this evolving building project, hopefully getting better over time. And so, yeah, and there's also this key term of the supremacy clause that I won't touch on now, but you want to make sure you review. So the Bill of Rights themselves, as the book tells us, we can look at these first 10 amendments as divided into 3 parts, right? The first one is I think the first 4 amendments, or maybe the first 3, protects basic individual freedoms. I don't have them all memorized. I don't expect you to have them all memorized either. The second set protects people suspected or accused of criminal activity. And then I know 9 and 10, as I said, that basically hold the Bill of Rights is not an exhaustive list. So we could have more amendments come after, which we know we did. We've had 17 more after the initial 10. And just because, again, you don't have a right written down doesn't mean, in America anyways, you don't have a right to it. So again, I spend most of the time in these notes talking about Amendment 1, Amendment 5, and our right to privacy. And so here is just this kind of short right that actually is the most important. It actually houses, I think, five different rights in it. So we think the First Amendment is like this simple thing, but it's very, very complicated. It's very, very action-packed. So you have Congress shall make no law respecting the establishment of religion, and that's going to be called the Establishment Clause, right? So the country itself does not have an official church or religion. Many other countries do. England does. Italy does. So in America, there's no official religion of the state. There's no state religion. And the government cannot prohibiting the free exercise thereof. So that's called the Free Exercise Clause. We get this kind of legal terminology. And so basically, the government cannot tell you how to exercise your religion. And there's again, and then what's interesting, if you guys go to law school or things like that, there are obviously limits, right? So we can't have human sacrifices or things like that. So there are limits to free exercise of religion, but generally speaking, the government cannot tell you how to practice your faith. Then we get into the next part, or abridging the freedom of speech, which you probably all know, or the freedom of press, the right of people to peaceably assemble, and the right to petition the government. So we get those last 4. If you consider the first 2 clauses 1 right, so we have 5 there. Again, I think free speech oftentimes gets confused. These rights only pertain to you as an individual with your relationship with the government. So you can't go to your boss and tell them to go F off. I mean, you can say that, but they're going to fire you. Whereas if you tell the president to F off, or a member of Congress, or talk about America in a bad way, or even call for a revolution, those aren't crimes. You're allowed to do that in this country, right? So it's kind of this amazing thing. And you can't do that in other countries. You don't have that right to free speech in, say, Canada or England. you can say things and you can get in trouble. Um, so we have here on religion, which we'll talk quite a bit about. I'm interested in this, and we'll have a homework next week about these kind of rights regarding religion. This is what my dissertation covers, is politics and religion. But it is important to remember that the United States was founded in a major part by religious refugees. So again, I always assume we all know the history of the United States, but we don't. You may not. But this is like the Pilgrims and Thanksgiving and things like that. But many people on the East Coast, when they were leaving Europe, were coming to the United States explicitly to be able to practice their faith freely and to avoid a state-founded government, right? So that's very much part of the American political culture that many of you are familiar with, but perhaps don't think about all the time in too much depth. So the ability to practice freely and unmolested by the government is a core aspect of American culture. The First Amendment forbids the government from favoring one set of religious beliefs over another. Again, that perhaps is debatable. Again, that's something I do my dissertation research on. But generally, that's supposed to be the case. And it is actually the case that the United States does handle religion much, much better than probably any other country. I know, again, I study this stuff, but like in Canada, right, if you're a public worker in the quasi in the autonomous state of or country, whatever, of Quebec, in Canada, if you work for the government, you cannot wear anything that denotes religious affiliation. So if you are a Muslim woman and you decide that you want to wear a headscarf or a hijab, you just cannot do it there. You can do it at home, but you can't do it if you say you're a teacher or something like that. These are not prohibitions that we have in the United States. Let's see. Yeah, so we'll talk about this much, much more when we get to that homework. But it says, establishing a general framework for deciding whether religious beliefs can trump general laws and policies has been a challenge for the Supreme Court. Those are what we call an accommodation, like an exception to a rule, right? And there's some court cases you should be familiar with from the readings. You don't have to know them in depth. Probably this Burwell v. Hobby Lobby is a pretty famous case of recent years with regards to, say, women's paying for contraception from the, what's it called, the Obamacare. That's not the right name for it. Basically Obamacare, and they were saying like, well, Hobby Lobby is a religious company, and like, well, we don't want to pay for contraception. Those goes against our beliefs. So what you'll notice with a lot of these religious cases and these civil liberties cases, and they oftentimes, in this case, you have a civil liberty, freedom of religion, freedom of exercise, and then you have someone defending, say, their civil rights. So civil rights and civil liberties oftentimes come into conflict. Real life, real politics, not espoused by politicians, is hard and difficult. It's not always fair, and there's never easy solutions in real life. So then we move into freedom of expression. Again, this is like something people are doing all the time right now. You're probably seeing all these things in the media. Maybe some of you are, say, activists and using your free speech in protesting or going and informing people about things. And so we have, again, the freedom of speech, freedom of press, the media, the newspapers, blogs, freedom of assembly, being able to gather together, and freedom to petition the government, basically. So this is really important one, these two, Neer versus Minnesota. The book talks about that. Again, I can't go into much detail. I'm trying to keep these under 20 minutes. But this Brandenburg v. Ohio case, the Supreme Court found that the only speech or writing that constituted a direct call or plan to eminent lawless action and illegal act in the immediate future could be suppressed. So if you're going to break the law or tell people, like, commit a crime, then the government can prohibit that speech. But other than that, if they're not going to have imminent threat or lawless action, then you can pretty much say whatever you want. And even that gets to be like, that's why we have lawyers. Even that can be debatable. But again, you can't have threats, basically. Like, hey, go kill that person. That's not part of your free speech rights. The Neer versus Minnesota stuff is, I think, if I recall from the notes, actually have my notes in front of me, but it has to do with the government saying that just because you have freedom of press, the Supreme Court ruled cannot engage in prior restraint. So that's an actual legal term. But the government cannot tell you not to publish something before the fact. So that's kind of really, really important with regards to, say, like publishing things like the Pentagon Papers, or even the book has the picture of Snowden. You can release information. The government cannot stop you, even if there's going to be, say, consequences, like you are going to go to trial for releasing classified information. You'll get in trouble for releasing the information, but it's still out to the public. The public has a right to hear it. Okay, so we get to this next section dealing with essentially like people's relationship with the state or being under arrest. And the reason why there are rights concerning this is because you as an individual, we are most vulnerable to the coercive apparatus of the state, meaning like, the guns and abuse and not in doing things against our will when we're arrested and in jail and in prison and things like that, right? Because when my hands are actually cuffed behind my back, like I'm literally, you can hit me, you can do anything you want to me. I'm as vulnerable as it gets. And so the Constitution spends a lot of time, concerned with individuals being vulnerable to the government. This is where the idea of like, you're innocent until proven guilty, those types of things, right? So no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in land or naval forces. So the military has their own code of law, which is still true to this day, or during times of war or public danger. So there might be exceptions. So again, maybe this coronavirus stuff falls under public danger, which again might allow for certain kind of violations of the law, which kind of have happened. Like, the government cannot make you wear a mask normally unless they pass a law, but it's kind of like, well, it's in the public interest. There's this danger, right? So the Constitution does kind of allow these extraordinary circumstances to be solved and resolved, right? So instead of having to wait, 10 weeks for the Congress to make laws regarding these things. Nor shall any person be subject of the same offense be put twice in jeopardy. That's called double jeopardy. So you can't be put on trial for the same crime twice if you're found innocent or guilty. Nor shall we be compelled in any circumstances of the case to be a witness against ourselves. So that's where you hear people say, I plead the fifth. If someone's going to call you to talk about a potential crime or self-incriminate, you do not have to say anything, right? And I'll get to this Miranda stuff in a minute. So remember that. You don't have to self-incriminate or be deprived of life, liberty, or property without due process of law. So, they can't deprive you of stuff without a reason. This is like when cops, if you get pulled over, you're being detained versus you're being arrested. Those are different kind of like legal statuses with your relationship of law enforcement. Nor shall be deprived of private property be taken for public use without just compensation. And this has to do with eminent domain. So if the government was going to build a freeway and your house is in the road, where the road would be, they can't just take your house. They have to at least give you money for it and have a good reason for public use. It can't be just like to make the politician richer. Maybe you'll find the C-SPAN video talking about Miranda versus Arizona, but this is a case from the 60s or maybe the 50s. I think maybe in the 70s. I don't know. But Miranda was a guy. He was under arrest, and he sued the state of Arizona, and they basically said you did not respect your Fifth Amendment right. They kind of like were, cops will be kind of shady and this or that, and he self-incriminated was the main thing. Did you do this? Do I have to say something? Yeah, you have to. Okay. And so that's where you get the Miranda rights. So again, when police if you get arrested, you're arrested when they read you your Miranda rights. This case made that applicable to all 50 states. And so, I'm sure you guys have seen this in popular culture, or maybe you've been arrested for something. The right to remain silent means that you do not have to be a witness against yourself. So it's essentially just like a short, abbreviated version for someone who may not know the Constitution to be aware of their constitutional rights. So the Miranda rights are really named after this gentleman Miranda, but they're meant to be like, okay, we're going to tell you what the law is by requirement, right? So now the coercive apparatus has to tell you your rights. And again, one of the things you'll notice about that is that you have the right to an attorney. If you cannot afford an attorney, one will be appointed to you, right? So that's a positive right. What I mean by that is in order to fulfill these kind of Fifth Amendment kind of requirements and other aspects of the Constitution, essentially taxpayer dollars have to go to paying for a public defender. So one will be appointed to you. So we have a positive duty. The government has to do something with regards to this civil liberty as opposed to not doing something like, say, in your Second Amendment. The government cannot take away your guns. They don't have to give you a gun, whether they can't take your gun away from you. Having an attorney is a positive civil liberty, if that makes sense. The government has to provide you with representation, of legal representation, regardless of even if you actually are guilty and actually a murderer or something like that. You're still entitled to these protections of the Constitution. So again, one of the things to keep in mind, even with these kind of modern controversies and maybe these other controversies that we all agree on, like, bad people should go to jail, is that we know the system's actually working when it protects the worst of us. And I think the American system does a better job of that than most other systems, even if it could still be better. It does protect the worst of us. And so we would want the bad people to, go to jail, but we still want them to have a fair trial, right? And have a lawyer represent them. Or at least I would argue. You don't have to agree with that. Not let them burn. So then we get to this idea of the right to privacy. The term privacy does not appear in the Constitution or the Bill of Rights. This is why I think this is so important. Maybe it's a test question. The right to privacy is cobbled together from several provisions in the Bill of Rights. We can understand the right to privacy to mean a right to be free of government intrusion in our personal lives, particularly within the bounds of our home. But we know there are other aspects of privacy that maybe we're going to have to make a constitutional amendment of. It's like, Apple and Google knowing all my stuff. And they invade our privacy all the time. Every time you guys use your credit card and buy stuff, those companies sell that information to the stores so that they can target you. That's part of the reason why you get these phone calls, I'm sure, of telemarketers telling you to go buy something. So I generally think, privacy as technology gets more and more developed is something we're going to care more and more about. And like with other rights, like say with we get to abortion issues, because it's not explicitly written down, this becomes a weakness. We're going to want these things actually addressed in actual language. So then we get into these cases that didn't deal with, or policy that deal with, say, privacy. Griswold v. Connecticut and Roe versus Wade is the famous one that kind of didn't legalize abortion. This is why it's such a contentious thing. It allowed women to have abortions without being prosecuted, right? And it's not because you have a right to an abortion. It's because you have a right to privacy, which means that what you do with your body is no one's business. So again, if you were to become a lawyer, if you're an activist, if you research these things, you can see how this is like very tenuous because it's not an actual right that, say, women have to their body, which they may or may not be able to have or should have. That's up for you and your own beliefs to concern. But legally speaking, and again, I'll say this a lot, I'm not a lawyer. That right does not rest on this like right to do something. It has to do with actually privacy issues. And the Connecticut one's the same thing. It had to do with, I think, a married couple in Connecticut, the Griswolds, wanting to get contraception, and the doctor wouldn't do it for whatever reason. It's like, well, it has to do with the privacy of the family to do that. And then the Patriot Act is an act that happened after the 9/11 2001 terrorist attacks to essentially listen to people's phone calls, check their messages, essentially violate people's privacy from the government, right, in order to essentially stop or mitigate terrorism. And that's something that has to get renewed. So it's not a law, but it kind of violates this kind of idea of privacy that we have just discussed. So hopefully you're finding these discussions enlightening. Please go through the rest of the amendments as discussed in the readings. Take the quizzes and things like that. And I think I'm going to do one more video and post it for you all. So I'll listen to your questions in class, and hopefully we're all kind of getting a sense of what the expectation is for everyone. So see you guys in the next video and the next class section.